Court don't reject federal government evidence against Nnamdi Kanu. Country people, welcome to Synod Media. Abeg, if you never subscribe to our channel, make you do so now. Put on your notification button. E go give you alert once we drop updates. Also, make you like, comment, and share our video. The ongoing trial of the leader of the Indigenous People of Biafra, Mazi Nnamdi Kanu, don take new twist on Thursday as the Federal High Court for Abuja, where the trial dey take place, e don reject the evidence wey the federal government dey try to submit against the leader of the proscribed Indigenous People of Biafra. Justice James Omotosho, for in ruling, he agree with the argument of the defense counsel, na be the lawyer for Nnamdi Kanu, when his name na Paul Erokoro, senior advocate of Nigeria. He said the Supreme Court don rule before, say before you go fit take any extrajudicial statement from a suspect, he say in lawyer must dey present. Justice Omotosho, he con hold the view, say although the provision of the Administration of Criminal Justice Act ACJA 2015, he used the word may to mean that the presence of a lawyer to a suspect is not a must. While he dey make statement, he no go fit close his eyes to the decision of the Supreme Court. Na there news report don talk before, say the judge stand the matter down, make e for deliver a ruling whether dem go fit admit the evidence wey the federal government dey plan to tender as exhibit. This development so e come about after the lawyer for the federal government, wey his name na Suraj Saida, senior advocate of Nigeria, and the lawyer of Mazi Nnamdi Kanu, Paul Erokoro, senior advocate of Nigeria, they come adopt their written addresses and they come argue their case for and against the propriety of the evidence in question. And there the judge come call for a trial within a trial. So as in the rule, after that trial within the trial, now there the judge, Justice Omotosho, come hold, say the issue now whether with regard to the evidence when they bring before the court, whether the statements of Nnamdi Kanu they admissible for law. He said the burden of proof in a trial, within a trial, it dey on the prosecution to prove in case. The judge can talk, say for the mind of the court, the defendant, when he be Nnamdi Kanu, he no fit establish the allegation when he dey make, say they force am write a statement. He say because the video recordings, e show, say Kanu, he dey relaxed when they interview am by the Department of State Services operatives. He say make you look the video and make you look the statement. He say they show say they be the same. He say but as a judge, the court no go fit close im eyes to the fact say Kanu don dey talk for the video, say in statement dem that they take am without in lawyers dem, say they not dey present. The judge can hold, say the relevant laws e state say under section 17(2) of the Administration of the Criminal Justice Act, the statement of a defendant e say may be taken in the presence of a legal practitioner of his choice, or where he has no counsel, an official of the legal aid council shall be present. Omotosho can say the Supreme Court don rule several times that the presence of a lawyer for a defendant when e dey make confessional statement e dey mandatory. E say security agencies dem must comply with the relevant laws when e mandate the presence of a defendant lawyer. E come say this act so e dey tied to the fundamental human right of every Nigerian. Justice Omotosho come talk say the charge wey dem bring against Kanu e say na very grievous one o. So that kind of charge e require say im lawyer suppose to dey when dem dey record the statement. Na there the judge come say for the video recording to survive for a criminal trial, e say e must show say the lawyer of the suspect e dey there when dem dey record am. E say the statement dey inadmissible because of the omission wey the prosecution make. Wetin that one mean? Be say the court no go fit admit the statement wey federal government dey try to bring say Kanu make with them. The judge come talk say the 2015 statement wey dem obtain from Nnamdi Kanu, e say dem dey inadmissible in law because im lawyers no dey present. Na there the judge come expunge the video evidence and statements obtained from Nnamdi Kanu on these grounds. The judge come say the objection of the defendant counsel is upheld. The statements of October 23, 2015 and November 2015 when they earlier admit for evidence, the judge come say they are rejected. Justice Omotosho, he come proceed to mark the statements when they reject and also expunge from the court records. The video recordings of the interview and the statement writing sessions when Kanu do with the DSS officials for October 2015. The video when they earlier admit for evidence by the court during Wednesday proceedings, and they come mark am as exhibit PWQ and PWR. On Wednesday, Night Justice Omotosho order a trial within a trial when Kanu reject the extrajudicial statements when the federal government wan tender against am. The IPOB leader, he don allege say the statements e make am under duress. Kanu come allege say the DSS officials when he interrogate am, they deny am access to im lawyers. They threaten say they no go allow am bail, and the 1 hour when doctor say make dem give am every day to take dey receive fresh air in view of his health challenge, they go withdraw am. He say one DSS investigator threaten am, and he described the investigator as Mr. Brown Okwaba, an assistant director of investigation. He also allege say interrogators they ask am make he say things about ex-president Jonathan and former governor Rochas Okorocha of Imo, and he say those ones not be in words. He also say they keep am for underground cell and for solitary confinement. He can't claim, say the video recordings when they play for court, he say the editor, the federal government witness, one DSS operative. He can't debunk the allegations. He say they not be true. The witness insists, say Kanu, they not force him to do any of the things when in the claim. He say he not dey under duress or coercion. The witness comfort Kanu claim, say they not keep him for solitary confinement for any underground cell, and say he not suffer any form of ill treatment. He say they give Kanu preferential treatment and they serve am bottled water during the interview. The witness say he dey shocked to hear the allegations wey Kanu dey make. He also say nobody tell Kanu make he say anything about Jonathan and Okorocha. He say everything when Kanu talk, he say he talk am freely and truthfully for the interview. That one I make Justice Omotosho come say make they conduct a trial within a trial. Make they take ascertain whether the things when Kanu do, he do them voluntarily or otherwise. And now the ruling don't come now. Say, even though, say, enough he establish the claim, say they force and do any of these things, but in the face of the law, because in lawyers not they present when they take those statements from him and the video recording, the court not go accept those documents as evidence. Country people, wetin go come become of the case against Nnamdi Kanu when all those records and statements when they make, court don't reject them. Make una give una feedback for the comment section.